Alex here with part 120 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version, as the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Every 10th video, I also like to remind my viewers, if you're not getting every single email notification on the My Docket series, it's probably because you are only a subscriber. If you want to make sure YouTube gives you every single notice, you're going to have to go in and click on the bell notification button to make that happen. We go into my ex's attorney's opposition to my motion to modify child support. I'm sure I was frustrated at the time. I really can't recall a whole lot of my mindset. I remember the sort of underlying positive emotions that I felt because of the fact that the Supreme Court published that decision, because of the fact that the wheels of justice were turning in the other case that I filed, which is the petition for writ of mandamus case. But at the same time, I also felt like this whole thing was pointless. The dispute over the benefits cards, the dispute over the backpack, and now we have the dispute over the child support. And when it comes to child support, it's formulaic, it's numbers, it's math, the law is the law is the law. But it's just, it's dealing with another parent who is not an absent-minded, uninvolved parent, but is rather a parent who is actively taking steps to add as much to the conflict as they possibly can. And that is what I think the foundation of high conflict child custody is, and why it never ends. It's not, I think too many people feel like the parents aren't trying hard enough to work together. And that is not at all what high conflict child custody is. What it is one of the parents, not even necessarily both, just one of them can do this. One of the parents who's doing everything in their power to not come to an agreement, who's doing everything in their power to be unreasonable. So it's this is, I think, where so much of the disconnect is with both the attorneys and the judges. They don't get this. They think it's just two people who, if they put a little bit of effort into working together, they'd be able to get past these issues. And it's like, no, you guys are wrong. It's not two people that are just not trying. You have one person who's trying a whole lot to make sure that this case doesn't end. And I think if more attorneys and judges understood that, their approach to dealing with high conflict child custody litigation would change. It would be a lot more effective. And I think there would be a lot less damaged children as well. But anyway, I think at this point in time, what we're going to have to do is just jump into the document for this particular video. So let's go ahead and take a look at what my ex's attorney has filed. Here we have my ex's attorney's opposition to motion to modify child support. Standard introductory paragraph indicates that my ex is appearing by and through her attorney, Ms. Berning, and that she is opposing my motion. She doesn't really state the detailed title of the motion or the date that it was filed. These are two mistakes in my opinion, but as I've mentioned, even if you don't do this, usually the court can figure out what it is you are responding to. Next, we have the points and authorities. She goes straight into the facts. Number one, she's talking about a stipulated order that my child support obligation is $550. Okay, so this is most of the stuff, guys, I've already gone through in previous child support modification motions. So I'm going to glaze over this a little bit. I won't skip it, but I'm not going to read necessarily from the paragraphs. The first thing that my ex's attorney is doing is coming up with the previous dollar amounts and the child support that was ordered based on those previous dollar amounts. Okay, she goes into my allegation that I am now earning less income. She goes into the assertion that I am reporting to have recently designed websites. Next assertion is that the state economist for Nevada reports the labor force grew and that the jobless rate fell. Okay, I'm not unemployed, I'm just saying I'm making less. But you know what, this is what they do. Attorneys like this, they leave out all of the stuff that actually, and I guess this is what they're supposed to do, is they cherry pick the facts that make you look bad and point out only the stuff that supports their case. And I mean, on one hand, That's kind of what you're supposed to expect from them. I talk about that in the video, win at all costs. But on the other hand, these aren't typical lawsuits where you have two sides going at it, where one needs to get money, or when the state is trying to put somebody in jail. These are tricky situations where you have two parents trying to take care of a child. And so sometimes the win at all costs mentality, it goes beyond what I think the ordinary person expects when it comes to cases like this, where you don't really want one side to blindside the court and win, because that might not necessarily be what's good for the child. But again, we have to get used to this because this is how they are. And she's done things that are, you know, a lot more conniving than this. This is kind of within, I think, the boundaries of win at all cost lawyering without going too far. But let's go ahead and go into the argument. We have here that the court can modify child support when it finds a change of circumstances, and she cites the law. She cites another statute which discusses the requirement to modify if the change is 20% or more. And then she goes right into the willful underemployment statute and case, which is NRS 125B.080 subsection 8 and mini-R. Again, guys, this law has changed. So just giving you an example as to what things were like in 2013, but keep in mind this has changed. And then we have here my request to receive more child support on the basis that I'm working less because I'm attending college. More like I'm taking advantage of the fact that I'm working less by going to college. I'm not... Anyway, she wants to present it this way. She wants to mischaracterize it this way. That's fine with her. And this kind of gives you guys an example as to what to expect from your opponent's lawyer as well. It's different. It's one thing to take advantage of your reduced work hours by going to college. It's another thing to go to college on purpose just to reduce your work hours. Those are two different things. And again, this doesn't even go into the fact that graduating will quintuple my income. Going into the next assertion is that the economic downturn. So she's just trying to controvert the fact that there's an economic downturn. And then here I'm talking about paying child support with the income. Okay, so it's still in line with the willful underemployment statutes. Here we have the certificate of mailing, and this is Rule 5, which discusses mailing something to somebody by mail, which is what she did here. So she put it into an envelope and sent it to me in the mail, which she's allowed to do under Rule 5. Actually, I guess it's her worker, this Barry Blau guy that did it. Next assertion, or next page, deals with whether or not she has to pay a filing fee, and in this case, she doesn't. Or wait, does she? No, she doesn't. And then we go into the index of exhibits, which is a press release. Here we have Exhibit 1, and we go into an article in the news which discusses Nevada's unemployment rate. Going into the aftermath, I didn't file anything, so I incurred $0 in costs. My ex's attorney filed one opposition, and that was a free filing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, even though it's a pretty short document, she would have had to put some work into it. She would have had to communicate with my ex. I don't want to say it's an hour because it was so short. And most of it seemed like it was copy-paste. I'm somewhere between a half hour and 3/4 of an hour. And I think under the circumstances, I'm going to lean towards a half hour. I feel like in my last video, I kind of went a little above. So this video, I'm going to balance it out by going kind of a little below. So I'm going to go ahead and say a half hour in attorney fees at my ex, which at the rate of $250 an hour comes to $125 in attorney fees for my ex. As for my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.